All right, everybody, welcome to the Creative Finance Collective. If you are new to the show, thanks for joining us. We're taking questions on creative finance, and I'm bringing people in as they come. Scott, I can hear you. Can you hear me?
I got you, Bubba.
All right, you got me. Nice. Well, we're live, and we just started. I know that I expect to see Sean, and I think Alan over in your neck of the woods is coming on too. How you been? I haven't talked to you since the new year.
Do the words crazy ring a bell?
Uh,
And I'll get this fixed here in just a minute, my friend. Trying to get.
Sure. While Scott works on his video device, if you're just joining us, the Creative Finance Collective is an opportunity for lawyers like Scott and I and others to get together and talk about creative finance. But really, we're here to answer any questions that you have as an audience. And one of the things that we're going to be doing is, if you don't have any questions, and Scott and I cease being interested in what each other has to say, we're just going to cut it off and because we can get together at any time. So if you have questions, make sure to post them in the chat, and that makes our time here more fruitful for you and for each other. I see that looks like Alan's trying to get on here too. Alan, can you hear us at all? Alan, if you can hear us, no videos coming through, so try again.
I think he's as technically challenged as I am sometimes.
Is it a Texas thing?
Hell, I don't know. My IT guy changed some settings and whatnot that knocked out the ability from my main screen or my laptop to do this. So I'm on the phone right now instead, and it's like, Anyway.
Yeah.
Just frustrating as usual is what it is.
Yeah. So if you're new to the collective, Scott hasn't. We're only a week or two into the year, but Scott is a Texas attorney. Not only is he an attorney, he is a real estate investor too. So Scott Horne comes at this from the investor angle as well as the lawyer angle. Alan, can you hear us?
I can.
All right, sounds good. We've got Alan Seschker from Texas. Also, how you been, Alan?
Good. Just rolling along. As Scott knows, the general consumer market for real estate is a little bit slow, but the investor market's fast.
I just finished a 2-hour little in-office seminar, guys, on RMLO stuff, Dodd-Frank, SAFE Act, other things. But I go back, guys, to 2010, 11, 12, and we were creating a company back then that I actually called, it was the Owner Finance Solution. It was the National Institute of Owner Financing, and all this stuff had a huge amount of information we were putting together for marketing and whatnot. But as I was digging through that, going through old seminars we used to do and whatnot, I came across a piece of information. It came from I'm trying to think the name of the group that put it out, and we'll pull it up real quick. It came from a Fidelity National Financial, so not Fidelity Title, okay? And I have no idea where it came from. I'm guessing this is some kind of a mortgage thing. And it was talking about wraparound mortgages, again, wrapping around FHA loans and things like that. And I know we've all kind of heard that in the marketplace a little bit. I know, Andy, we had talked about this months ago at one point in time. And it was just coincidental that I ran across this. I haven't really had a chance to read it in detail. And this goes back to 2012. I'll tell you how old it is. And trying to go through here, and they try to propound, I don't know where this came from or what, using a HUD letter that came out in December of 1990 that they supposedly sent to title companies and real estate brokers talking about circumventing credit qualifying requirements on assumptions.
That's the blacklist letter. That's what they all once in a while to tell other title offices to stop insuring FHA and VA wraps.
Yeah, but the question becomes, because in our title company, Alan, we don't make that decision. It's an underwriter decision if they want to do it. And what blew me away is we're closing a deal right now. I say we're closing. We're preparing. Well, we're closing it, and we're ordering the title evidence through another title company that's in the DFW area. I've never heard of them before, but they are issuing title on an FHA underlying loan on a wrap. And I just went, holy cow, none of my underwriters will touch it.
So I have a long sordid history with my FHA and VAs insured. And what I've learned is, first off, that 1990 letter caused an attorney who closed a wrap back in 90. They blacklisted him. And since that blacklisting, I've been able to find exactly 0 cases of anyone being blacklisted since then. So just 33 years, we've had one. And so what I'll do is I'll sit down with underwriting counsel and I'll say, listen, we know what we're doing. I'll sign indemnifications, close and insure these things. There's no real risk, et cetera. And I will get an underwriter that says, okay. And then I go and change agencies and I go back to the same underwriter and say, hey, we were insuring these, but now I've got a different individual I'm talking with. And they say, absolutely not. And so I recently sat down with a title underwriter, to be unnamed. And I said, hey, we want to close these things and insure them. And they said that in their reading of the Senate Bill 43 statutes, since it says you have to close with a law or title office, they said no mobile notaries. You have to close in a law or title office. And clearly they're wrong. And so I elected not to join up under them. And then fast forward, I've partnered with I've gone under an agency now. And I said, okay, good. Y'all didn't really tell me who's insuring your FHAs and VAs. And sure enough, it's the exact same underwriter that I was talking to before. So I think it's a left hand, right hand. I think some decisions are made at mid-level range, and they're not getting up to the high level. And then they insure them for a while, and then they find out what's going on, and it switches. So it's been a circus for the past 20 years on that stuff.
Wow. I just find that just interesting how that is. But, you read this thing, and I get it from a standpoint of title underwriting.
Uh-oh.
Seems like we might have lost you, Scott.
And FYI, my technical issue, I use Firefox. This platform doesn't like Firefox. You got to go through Chrome.
Oh, yeah, it can be finicky. Let me see if I can. Scott, can you hear us okay? Looks like we lost him.
Well, let me jump on that. The letter that he's referring to, it straight says if you close and insure a wraparound of our FHA VA, we will blacklist you from closing any government-backed loan. Again, any file that has a government-backed loan. And so it's toothy. It sounds scary. It would take out a title insurance underwriter agency, fee office, whatever. So I see the concern by the underwriters. It's just when something hasn't occurred in 33 years, I think it's not going to occur.
Yeah, that makes sense. So we have a couple of questions, and as we said before, if you're just now joining us, this is the Creative Finance Collective. We're here to talk about creative finance and things related to real estate, and we'll take questions and answer those questions along the way, and we'll keep going until we don't have any more questions. So we have a couple questions. Question 1, what is the difference between a lien and a judgment? I'll take that, and then Alan, maybe if you want to answer it from a kind of a closing attorney's perspective. But the difference between a lien and a judgment is a decree entered by the court declaring an amount of money that somebody owes, or it could be affirmative relief, declaratory relief to declare something to be void or of no further force and effect, or declared to be the owner of something. But that's a decree from a court. A judgment could be a lien, and we could talk about examples of when a judgment is a lien, but a judgment doesn't have to be a lien. A lien, by contrast, can be a judgment, but it is something that acts against a particular asset that you have, whether it be real property or personal property, and affects or impairs the ability to you know, move that asset without the payment of whatever the underlying debt is, relating to that lien. Would you guys add anything else?
I I can let's take a memorandum of contract, for example. That's not a lien. That's notice to the world that there's an interest right in a property. Abstract of judgment, like you said, can be a lien. Mechanics lien would probably be, I guess, the best example of a lien. That is a specific claim to a property in regard to X dollars. I consider them all the same from a title perspective. They're all some type of encumbrance that's going to cause us to have to get rid of them in order to advance forward. So the semantics of is an MOC a lien or not, I don't care. Yeah, it's a lien, if you want to call it that, but it's actually a cloud on title or an encumbrance. So to answer the question, if someone was asking me that question, I would say they're all the same from an effective standpoint. You have to get rid of them to advance forward.
Well, let me ask you a question, Alan. So, guys, sorry about my phone going in and out, but I think I got it fixed. I'm going to go back originally before I jump into the judgment thing here for a moment, just to wrap up the FHA thing. I always wonder, I get how it affects a title company possibly in the decision process, but I wonder how it affects a closing agent, such as Alan's law firm or our law firm, where you close outside of title or not. I don't know that answer. So in regard to your judgment lien question, Andy, anybody can get a judgment lien or a judgment, and it's great. But until such time as they abstract it, which, as we all know, means to get it certified by the court and then record it, it doesn't become a lien on property. Now, here in Texas, a judgment lien is not supposed to attach to a homestead by operation of law and as per our Constitution. But title companies years ago made a decision that they want those removed. And of course, today we have a state statute that allows us to remove it from a homestead within 33 days. But someone has to be proactive in making that happen. Then, of course, you got to watch the lifeline of that judgment lien to make sure it hasn't run its life and hasn't been renewed. Likewise, with what Alan just said, you have a mechanics lien that is out there, and it does create a lien on the property, and it's subject to some various statutes. I think those are, if it's non-owner occupied, it's 1 year that it's valid, and owner occupied is 2 years. In which case, if someone wants to foreclose under it, then they have to do that. But I would love to take a minute and just talk about these memorandums of contract that came up, because they do not create a lien on property, period. Do they create a cloud on property? And the answer is maybe. Now, if you take a deal that there's a memorandum of contract that's out there, and it shows up on title, and these memorandums these people do are pretty rinky-dink nowadays, to be honest with you. Most of them are. You don't know if they have a valid contract or not, if they put up valid earnest money or not, or anything of this nature. Someone just says they suppose we have a contract. That's it. But you can never get a hold of them half the time. They can't demonstrate things half the time. And again, probably 90% of the time, the contracts aren't necessarily good. But, and the next question becomes, does that person who filed the memorandum even have the ability to perform under the contract if it's a valid contract? And I'll tell you that it's been my experience that probably 75% of the time, these people who put these houses under contract don't have any financial ability to perform to close the deal without finding a back-end third-party buyer somewhere. And so the question comes from a title perspective. If it shows up on title, most underwriters probably won't close it. They want it removed just as a factor of safety. But back out for a minute, and what would you do if you were closing it in a law firm, no title being issued, where technically it becomes a breach of contract between the seller and that particular investor? I mean, do you close the deal since it's not a lien on the property?
I wouldn't close it. And so I wouldn't close it. One of the larger cases that I ever was involved in was a case where back when the 2006, housing market, and the property was purportedly under contract. The seller thought that the buyer breached and they had terminated the contract. And so my client goes under contract for the property with the buyer. They open escrow with the title company, and there was an outstanding private loan out there. And so the escrow officer happened to know the other title company that was servicing it and somebody within there as like a friend. They had worked together before. So that escrow officer called up that other title company and said, "Hey, can you give us a loan payoff?" And they said, "Oh yeah, what's the address?" And so they typed in the address. "Oh, that's interesting. We have an open escrow for that file, but I don't know what's happening. Maybe it closed. It's been open for a while. Maybe it terminated or whatever." Sent over the loan payoff, left it at that. And my client buys the property. Old buyer comes out of the woodwork, records a list pendants, files a specific performance action, brings my client into it, locks up the property forever. Market turns, starts going down. It was a colossal mess. And you know what the court said? They said, "You title company," and of course the title company never told us what that conversation they had with the other. They said, "Look, you are an agent of the buyer. And when you got that information from the other title company, that buyer was deemed to have known that information when they closed, even though my client had no clue. They're deemed to have known it. And because they're deemed to have known it, they knew of the prior claim out there, and that claim is valid and they can pursue it and lock up the property." I think if you see that memo out there and you don't have a clear cancellation, I think you're going to get stuck in a very similar lawsuit potentially and have issues. And of course, there were claims against the escrow agent for not informing us, not, letting us know about this other escrow out there that they learned about and kind of hid, even though they would claim it was just a conversation in passing. In any event, I wouldn't. If I saw that memo out there, even if I were confident it wasn't valid, I don't know that I'd be comfortable closing without some release and disclaimer and a bunch of other things signed by the parties.
So
indemnities.
As we all know, though, what these yahoos do, and I say yahoos, these are investors who, they get someone to sign a contract, hoping they have a valid contract. They run down immediately, do a memo, and then they want to hold you hostage when that seller wants to close. In fact, I had a deal just recently where a memo was filed on a property. The property was going to foreclosure. There was another buyer that had and the front end guy couldn't close the deal. And he refused to release the contract to another buyer without a fee being paid. And the property went to foreclosure and was foreclosed on. And you see those kind of things and you kind of go, okay, well, could that buy a lawsuit? Well, maybe. So you sue investor one out there, but they don't have a pot to piss in it, most likely, in most cases, as we know. So that's kind of spinning your wheels. They don't care that the seller got foreclosed upon. And so, at least here in Texas, I keep wondering when something's going to be put in place regarding the release of these daggum things.
Well, they don't have a statute of limitations on them either. So we know how long a mechanic's lien's there. We know how long an AJ is there. We know all this stuff. Since there's no statute governing them, in theory, I've seen about 5 cases where they've moved it over to Schedule B and still closed it. It's still going to be there 10 years, 30 years, 100 years. So I agree with you 100%. We need a statute that fixes it.
Yeah, I think that they probably have a 4-year life, Alan, just because, under the contract, you have 4 years to close under specific performance. And after 4 years, you lose that. So I think that might be the unspoken, time frame of it. But you're right. There isn't a specific time frame on it. And so you kind of don't know, but you can second guess it that way to a certain degree. But it's just, I look at it here in Texas and I see these things happening and I see it's just the new fad that everybody wants to do. And it's a problem. It's as bad as the solar panel issues that are out there.
Now you heard about the fellow up there in Louisville, didn't you?
Nope. Tell me.
And I'm smiling. Shouldn't smile. Went out there and he would get these properties under contract. Same exact scenario you're talking about. Some of them went to foreclosure. People were getting mad. Apparently enough people got mad enough that he put one under contract, and he would send over proof of funds, making his offer, stronger. And it turned out that the issue wasn't him getting it under contract and not closing, but his proof of funds were fraudulent.
Oops.
And so it was a Louisville guy, and he got taken down in handcuffs and got free room and board for a little while. I don't know what happened with his case, though.
Well, it's kind of nice to see that a little bit when that happens.
It is.
Again, just to touch on that, that's just the greed factor again in the marketplace that is just so phenomenal. Everybody thinks that they can do this, that they can hold everybody hostage, they can force somebody to pay you money. Whether or not they have a good contract, whether or not they can perform under or not, they don't care. And it's a really telltale sign that there needs to be a fix to that, at least here locally right now.
If you're just not joining us, this is the Creative Finance Collective. We're taking questions throughout the hour or until there are no more questions. So we have a couple questions from some Facebook users. One, which is a follow-up to Scott and Alan, your earlier discussion. They asked, so FHA is not a title insured
in subto.
Say again. I had feedback.
Yeah, I've got
feedback too. So
FHA is not a title insured
when subto.
Question mark.
So the great majority of underwriters are not insuring those. There are some in Texas at least where they're insuring them. So you can find insurance on them.
So we have another question from a Facebook user.
Not in Arizona though. You can't get insurance on them in Arizona at closing, but there are title insurance companies that will behind the scenes insure them subsequent to the closing.
Oh, interesting. So they're not subject to that 1990 threat letter.
I think, their position is if we don't have our escrow name and stamp on the warranty deeds and stuff, I don't know. I don't know why they, what the thought is, but they won't escrow them. They don't want to be the at the forefront in the public realm doing the escrow. Once it closes, they'll then, insure, subject to, of course.
We have
I'm gonna look up the letter again real quick, see if the language answers that. Sorry, go ahead.
No. That's okay, Alan. Another question from a Facebook user. Can you guys speak about forced sales when two people are on the deed and one that isn't paying the mortgage refuses to remove their name? I think what they're probably referring to, or the question here, is a partition action, the ability to remove one party, one co-owner off the deed. In Arizona, that requires the filing of just what I said, a partition action. It's a lawsuit, like any other lawsuit. It has to be served on the party, and you go down the process like any normal lawsuit process, which ends in effectively the partition in kind or by forced sale of the property. The original idea of a partition was the idea that the court could draw a line down the center of property and split it, and everybody goes their own way. In modern kind of conceptions of real property, or even in ancient ones, that's pretty difficult to do, to draw a line down a piece of property. So that's not how it's done anymore. It's typically done by a forced sale of the property, and then the owners will split the equities. And the cost of something like that and the time that it takes to do something like that is largely going to depend on, like every lawsuit, how well the parties get along, if they're willing to come to terms on whether they're going to settle it or whatever else. But that's a partition action. In Arizona, unfortunately, you're not entitled to an award of attorney's fees in a partition action. So unless there's a partition agreement that the parties entered into and have the right to partition pursuant to some agreement they did. So each of the parties are going to typically bear their own fees and costs. Alan, Scott, I know you guys are primarily, for the most part, transactional lawyers. Is the process to partition similar in Texas?
It is. By the way, we do a lot of partitioning. Now, I don't volunteer myself to do I've got litigation counsel that handles it, but, we find it a very advantageous mechanism. Not usually when you got two tenants in common that you're dealing with, but it's usually when you have heirs out there where, you're able to pick up a 50% ownership interest, 70% ownership interest, but the other heir or heirs refuse to sign. I've got one going on right now down in Houston, where one of our partners brought a deal in where mother inherited. Well, when dad died, mom got her half of the property because of the way the dad's will was worded, and she got a life estate for the dad's other 50%. But after the life estate expires, it goes to a child and a stepchild. Okay, got it. So the question becomes, we were going to go in, we were able to stop the foreclosure back in December with the intent to bring the loan current and buy the 50% interest in the property and go to the other two children who would have the remainder out of the life estate and buy their interest. Well, the problem with that is they are at major odds with each other, and they don't care about the foreclosure or whatnot. And I'm still waiting for the probate counsel, who's doing some type of a guardianship for mom, to get back as to the validity of a power of attorney that the one of the daughters has for her mother or not, whether mom had the capacity a year and a half ago to execute that power of attorney. And this is one of those kind of deals that, you would hope the estate would wake up and smell the coffee, because they're fixing to lose the house to foreclosure, or, where it's, $40,000, $50,000 behind in payments, taxes. And my guess is it's going to go to foreclosure here in February again. And they're doing nothing about it. And we know they don't have the ability to bring the loan current, and they just sit on their thumbs doing nothing. But if you can get a deal like that, where you can pay the other heirs X dollars, either you do that and you get full ownership, or you go the partition route And oftentimes you can be very successful in buying the home and getting a great deal, subject to the type of transaction that's out there. The issue that you see here in Texas, or I see with partition, is it's cash intensive, and it's going to take anywhere from 6 months to a year based on the situation, because the court may want to bring in an attorney ad litem to represent the unknown heirs or the heirs that might be out there before they make a decision for partition. You got to appoint a receiver, and that receiver is going to sell the property and put it out to bidding. So if you want to buy it, you got to be the highest bidder. But if you know how to play the game the right way, you get the right circumstances out there, I think it becomes a viable scenario. Now, with all that said and done, being a transactional guy, like me and Alan, I just don't want to do the legal courtroom jargon, but my guys who do it love it. They thrive on that kind of stuff. So we let them have at those things.
Yeah, and there's a follow-up question to the hypothetical here, which isn't so, which I suspect is not a hypothetical, but we want to keep it and pay him off. So the co-owners, one of the owners is not living up to their probably 50% of the mortgage and not paying. So they want to keep the property and pay him off. Will the judge force him to remove his name if he hasn't proved any financial contributions? You really need to find out from the state that you're dealing with specifically, but in Arizona, that whether somebody hasn't paid or has paid, it's not like partition's not like a breach of contract. Partition is that two co-owners can't be forced forever to be owners. And the law allows them to partition that, and will distribute the equities accordingly when each party shows their contribution, what they've done, and what they're entitled to receive. The court isn't going to make a judgment in a partition action as to who gets to stay on or who doesn't get to stay on. You guys correct me if you think I'm wrong on that, but they're gonna force the sale of that property. And now that's not to say that you can't, and I've done this in a number of cases where you've got a party, you usually end up in partition because you've got one party that just refuses to sell. Well, if they can get an attorney and you can talk with them and they understand that the end of this road is going to result in the forced sale of this. So with that being the universe we're living in, that the property is going to get sold, I've got the financing, I can bring it to the table and buy you out. That can be an option, but that's usually going to be an option as part of kind of some sort of settlement resolution, rather than the court ordering one party off and the other party gets to stay on.
Yeah, I don't think any court's going to order one party to stay and one to leave. That's not going to happen.
Well, but
a forced sale.
I can see them. So I haven't handled one, but I understand that it's essentially two suits. It's a suit to force the sale and then a suit for partition. And if you get an order saying, all right, the sale is forced, you have to sell, then you come back as a solution. All right, well, let's get an appraiser. Let's get two appraisers. They can appraise it. We add them up, divide by two, and that's the purchase price. If one wants to pay that to the other, then so be it. That's the sale of their interest. I can see that occurring.
Alan, you live in Austin, Texas. That's kind of like La La Land. They just don't do that in real life, because usually what the situation is, it's really, guys, I've done so many of these now, and it boils down to personalities. One is living in the house, one isn't. And they have nowhere else to go. Or they don't want to sell it, but they don't have the ability to buy out the other. And the second one wants cash. And the first one doesn't have the cash to give them, can't get a loan for the property. And all of a sudden, you just get this head banging going on. And as much as what Alan just says is the common sense approach and how you do it, it's the cheap approach, and it works. so often the personalities just don't allow them to do it. And so you wind up in that. One of the things that I've seen so much of is, especially in a multi-heir scenario, let's say maybe you've got 6 or 7 heirs to a property and you're able to obtain the ownership of 6 of those. But number 7 just goes, I don't want to sell mom's house. I'm not doing it. I don't care, whatever it might be. But what I've found is when you can get the other personalities out of the equation, because there's usually some underlying current there where that's holding it up, then you can talk some reason into that final heir and get them to possibly sign a deed before you go through partition. But you do that, not, I want to say by the threat of the partition lawsuit, but sometimes that gets them to wake up and smell the coffee and realize that they're no longer dealing with their brothers and sisters or whatever it might be. They're now dealing with a totally independent third party who is saying, I'm fixing to sue you for partition. You're going to lose. It's going to be sold. You're going to get less money, through the partition than you are what I'm offering you right now. Why don't you just wake up, smell the coffee, and make the decision? Let's go get this thing wrapped up. And sometimes that works, but not always. You always deal with what I call the idiot factor out there, where no matter what the situation is, they just refuse to work with you, and you wind up going to court.
Yeah. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour until the questions run out. I have an interesting one here. We haven't talked about this, I don't think, on here. See what you guys think. From a YouTube user, watcher, what's your take on surplus funds after a foreclosure, ? Is it a viable strategy to find the former mortgagor and buy the right to those funds?
Well, here in Texas, you can do that, but you have to pay that person 80% of their total, whatever the amount of the funds is in the court registry in order to go do that. So it's viable along the way, but you're going to pay your counsel, probably $1,000 a pop to go down to court to get that for you. And again, with that limitation, you can't go there and negotiate with that person, because usually these people who are foreclosed on, they don't even know that they have money sitting in the court registry. They think that's just gone. So when you tell them they got money, it's great, but they bar you in Texas from anything more than making a potential 20% profit possible.
Yeah, and I met with someone that was primarily doing it in Tennessee, I believe, at first, and then brought it here to Texas, and he was doing spectacular. If done correctly, where you're minimizing your costs, like Scott said, it was a very lucrative business for that gentleman.
Yeah, you can do it. You just got to find them, get out there and get things signed, and then go to court. And it can be lucrative. I agree with you, Alan, but it's a business that, I think you have to really make it a business, not just play around at it a little bit.
Yep.
But I think it's a great opportunity. You just have to learn it and know how to find them, because there are others who try to do the same thing. And typically, guess who is out there doing it? Lawyers. Imagine that. Those greedy guys.
I think we all agree, those damn lawyers.
Andy, I know, but I don't know off the top of my head. I know there's limits in Arizona as well, as far as what you can, how you can be compensated when you do that kind of thing, like a finder's fee or whatnot. But there are people in Arizona that do it. But similar to Texas, there's a limitation on the amount that you can obtain and charge for the services.
So we have another YouTube question here. Sean, I think you might like this one, and maybe we can, there's a lot of ways to answer this question. I'm going to preface it here, but maybe we can think of ways to answer this in terms of how it creates problems in the creative finance transaction. But our YouTube watcher asks, what are common things you see HOAs do wrong? Now, like I said, we could spend the next day talking about the things we all think HOAs do wrong. But I know if HOAs don't follow what they're supposed to do, it can hold up the closing of a deal. As a closing attorney, Alan, what are there common problems you guys run into in closing dealing with HOAs?
I mean, what do they do right? I'm just joking halfway.
So
our pain point is the speed at which they provide us the resale certificate is difficult. Sometimes we have 3, 4, 5 days to close before foreclosure. And these guys are saying, all right, well, it's 7 to 10 days, or if you pay extortion fee, we can get it to you in a couple days. Texas came and regulated what HOAs can charge for this resale certificate. HOAs are now dancing around that, trying to make up names for things and charge more. So they're very slow, and they're for us world. In terms of doing things wrong, we had a situation, but I think this is a one-off. We had a situation where the HOA didn't file a lien for the dollars they were owed, and it was substantial, and so it didn't get put on the HUD, and there was a claim and a problem and locking the property down for a while. But that was a one-off, I think. So other than overcharging and going slow, they're just a problem to deal with.
Sean, I recall in the past, wasn't there a time when we were having a problem with HOAs claiming a lien for not assessments, but for fines, right?
Yeah. So in Arizona, if you leave your trash can out past 5 o'clock, your HOA gives you a $25 or $50, some ridiculous fine. Weeds in your front yard, they'll fine you, all of that. But the statutes are very clear that those are nothing but a number in a computer system until the HOA files a lawsuit and reduces that lawsuit to a judgment. And then and only then can it ever attach to the real estate. It's not a lien and will never be a lien. And so, but what we see HOAs do is, they'll get called up for a payoff statement. And then next thing you know, there's $1,000 in fines on the payoff statement. And you go like, that's not a lien. You can't claim those. Well, yeah, we can. They owe that money. No, they don't owe it. It's not a lien. You can't hold up a sale. You can't require the escrow, agent to pay this, out of closing. And of course, the seller doesn't want to pay it. And especially back in the short sale days, the buyer didn't want to pay it. And so we would sit there and just argue with them. And, I finagled my way to sending emails, basically forcing them into a position of, basically slandering title if they respond the wrong way to my email, and copied the escrow agent on it so that we could close the escrow. But, at the end of the day, it was difficult. It was a lot of back and forth, and, but they put it on there as though they're owed it and it's a lien. Well, of course, the escrow agent, the title insurer's like, well, yeah, we don't want to have them come back on us for $1,000, but it's like, the statute's clear. They can't, it's a fine. They haven't reduced it to a judgment. So that was an issue. The other thing that was an issue, although they cleaned up the law, is it used to be that the liens would fall off after 3 years. HOA, so past due assessments were only liens for 3 years. But the seller owed the money between 3 and 6. It was a personal liability of the seller, but not a lien against the property. That's what the statute provided. And so we would see payoff statements that would have, 5, 6 year old past due assessments on there. Now the legislature cleaned it up and said anything within 6 years is still a lien, but anything older than 6 years falls off. But they'll still even then try to tack that onto the payoff, knowing that it's not a lien, but hoping that the escrow agent will be like, well, we can't close, and then the parties just say pay it. It's very frustrating. I don't know about Texas either, but in Arizona, there is no we have all these properties, HOA managers running around. We can manage your HOA and we're, you know, this and that. There is not one agency in Arizona that license HOA managers. They basically run around unlicensed. Like, you know, I could start my own HOA management firm tomorrow, just form an LLC and say I manage HOAs and get an HOA to pay me to manage them. And I don't have to do any licensing. I don't have to do any training. I don't have to do anything. You can just be a manager and tell the HOA what to do, and you screw it all up, and it doesn't matter. There's nobody that can, you know, discipline you or whatever. It's a terrible system in Arizona, and I hate them. I regret the fact that I bought my current house here in Arizona in an HOA, and I made sure when I purchased our home in Wisconsin, it was not in an HOA.
I only see one problem wrong with all of that, Sean. You said that you had weeds in the front yard of your houses.
Well, that's
You
why he
don't-
doesn't want to be in an HOA anymore.
Yeah.
No, I didn't say I had weeds. I said if you have weeds, your HOA fines you. I did not say I had weeds. In fact, this is a true story. I'm looking out right now, and my wife's actually pulling weeds from our front yard as I look right now. True story. It's true. So we don't have weeds. She's very good about taking care of that.
Well, at least you trained her well.
Oh.
No.
Say that, okay?
Oh.
You know, I
Yeah,
think
we don't want to go there. We don't want to go there.
No, at least here in Texas, you know, the HOAs can get they can file suit and get a lien that they record out there. It's going to be like any other judgment lien, good for 10 years probably. I just kind of found it interesting when they changed some of the laws here a few years back for HOA foreclosures that, you know, if the HOA forecloses, and of course it's going to foreclose subject to any senior liens that might be out there of some type, and the homeowner wants to come back and redeem, well, the HOA can get their money plus a 10%, you know, profit. But if an investor buys the property and the homeowner redeems, they now get zero. They get just what the amount they paid and nothing else. No interest, no fees, no nothing.
Yeah.
That
So
made small changes like that.
So let me jump in on that. We'll have situations where investor comes under contract with seller, quote unquote, and we run title, and all of a sudden, you know, ABC Investments comes back as the owner. Well, it turns out there was an HOA foreclosure, and a third party bought it at the foreclosure, and those are very good opportunities for investors because you can then go and redeem that property. And, you know, they're usually, there's usually substantial more equity than what the investor paid. That's why they bought it at the auction, and you can recover that property and make it your own. And so I've helped about 5 or 6 different folks do that. And it's lucky when you find that.
I agree. If you know how to play the game, it's a lot of opportunity that's out there.
Yeah.
But I'm with you too, Sean. I don't like HOAs. I don't live in one, and I would try to avoid one like the plague if possible.
Yeah, I think there's consensus there. Another funny question. Somebody has a Black's Law Dictionary, I think, out. What happens when property goes escheat? I'll answer this. My understanding of escheat, so assuming I'm even pronouncing that right, ESCHEAT.
How
But
about
that's-
It's
What's
cheap.
it? Yeah, escheat, depending. Yeah. So, but it's just if my recollection serves me correctly, it's the reversion of property back to the state. Usually, that term I think is used in the estate planning context. So, if your will or trust fails and everybody predeceases, and there's nobody in your estate plan left to receive it, that the property could revert back to the state, and I think that's the idea there. I don't know if you guys ever have occasion to use that and create a finance or in title work, but that's my understanding of it.
I have never dealt with that ever.
We have dollars that are stuck in our escrow account, our title escrow account, that no one wants, and those dollars will escheat over to the state. And it's especially problematic with these investors that think you have to have earnest money for a binding contract, and so you have $10 earnest money, and we'll send out a check for $10 and they don't cash it, and then we send it out again, they don't cash it, and eventually that $10 is going to have to escheat over to the state.
And it costs you $100 to send out those checks that often.
Yeah, it's painful. It's pain. That's why I'm making it my life's work to teach all. Was it 19 million? How many people in Texas? To teach all that earnest money is not required for a binding enforceable contract in Texas.
No, but it's nice to have.
It is.
So we have another question from a Facebook user here. I've been getting a lot of subto students / investors on wrap to homestead buyer, looking for a website for resources to learn about all the regulations, Dodd-Frank Act, SAFE Act, RESPA, plus their state regulators. What do you all recommend send to consumer protection regulations? That makes
What state are they?
Yeah, I'm not sure. Let's see. Here we go. Hold on. I'm not sure. Facebook user, tell us what state you're in. I'm not sure.
My RAP University takes care of the federal laws, but only deals with state of Texas laws.
Well, how about this? I'm just going to look at this and answer the quick question for him. So, of course, Texas is probably the toughest state for wraparounds that I know of right now. With all the rules and regulations, the new Senate Bill 43, the wrap lending laws that came into place, and things of that nature. But what I have found from this podcast, I've been on some note podcasts out there where note buyers are trying to buy notes and they're buying wraps, and they don't know if they were ever originated right. But most of these investors don't even know what the SAFE Act is. And at least in Texas, we used to have a 5 property de minimis rule. Now we have a 3 property de minimis rule, in which you're now under that completely. But in all other states, the SAFE Act complies to the very first transaction, meaning you need to process that consumer home buyer with the RMLO and go through the full loan processing, which is a requirement because you've got to provide that consumer with all of the RESPA disclosures. And I don't know of a single investor who's going to provide the 36 RESPA disclosures to any homeowner. So here at the Owner Finance Network, through OFN loan processing, we can process buyers in all 50 states and help them get that done. So that's the first thing. I think the second thing that investors need to know in generality, without getting off too much in depth, is that in order to be under the Dodd-Frank Act, you have to do 5 or more transactions in a 12-month rolling time frame. Now, even though Dodd-Frank says that, we recommend and suggest you do your absolute best to follow it every time. It's how you kind of idiot-proof a transaction a little bit. But then I was just, excuse me, in our office little seminar here, going over just this exact topic, trying to explain to them what a QM mortgage is, which is something where the interest rate or the APR for the borrower is, at the APOR rate or below in order to have a safe harbor. But where most investors are going to live is going to be in that what we call the high priced range. Because in Dodd-Frank, your first range is the QM level. Then, of course, there's the high price and then there's the high cost level, right? And we want to stay in that high price level where we're going to have what is called a rebuttable presumption that we did everything right, that, we're 8.5% plus the APR on an APR calculation or below that. And today that's about 16%. So it's pretty easy to be below that standard for an APR. But I think the biggest thing is, and the reason you want to process that buyer every time, is that ability to repay rule that you have to follow to ensure that that borrower has the ability to repay the loan. So even though you may not be under Dodd-Frank, that's a huge thing that you want to follow, because I think the last thing any investor wants to do is get in front of a judge and be accused of predatory lending in some format where, you know, I closed this deal and got this huge down payment knowing that the borrower could never make their monthly payments.
Yeah. And just to add some specifics, so the question, it's weird. I can only see when it comes from a Facebook user, just that it is a Facebook user, but he identified himself. That was Mark Monroe asking the question. And I don't know if you guys have met Mark. He was on our podcast a while back, but he's out of Florida, and he's got a large Facebook group following with over 100,000 members, and so that's where that question comes from. But I think they were looking for really resources that apply to all the states, not just specifically Florida or anywhere else. And I think that might, Mark, if I can think of one, we'll shoot it over to you. I'm not aware of a website that gives all the state ones. Like you said, Allen, like Rapp University and some of those are going to tackle all the federal ones, right?
Well, you know, Andy, Dodd-Frank and the SAFE Act is federal, so it covers all 50 states. So does RESPA.
Oh yeah, right.
So that's going to be the same wherever you go.
Yeah.
And the investors don't need to be experts in Dodd-Frank or the SAFE Act. I don't want to be an expert in that arena. All I want to know is I want to know what it is I need to know to stay compliant, to keep my nose clean. You know, how do I do things every time to be smart so I don't, you know, breach these rules and regulations? And learning how to follow the SAFE Act and Dodd-Frank every time is just a smart thing to do. And it's not hard. Just do it. And understanding some basics, learning some things that are basic, learning the utilizing an RMLO each time is just the way to go.
Yeah, I agree.
All right. Well, guys, we're right at about an hour. Lots of questions. Appreciate all of your time. And we'll get together again and answer more questions here in about a week or so. And but appreciate it, and you guys enjoy your week.
We'll
Good
see
seeing
you
you
guys.
guys.
Good seeing you, Alan.
See you.
All right.
Bye.
All right, everybody. Have a good one.
You too.